Welcome everybody. Welcome to the first webinar of the new year from the EUSME Centre. My name is Anne Maddy and I'm the Marketing and Communication Manager here in Beijing. Today we have our in-house legal advisor, Ludmila Hiklova, taking you through the steps on how to work with business contracts in China, specifically how to minimize risk for your SME. Hi Ludmila.
Hello everybody.
So just before we get started today, just a little bit of background and some updates from the centre here in Beijing. So following our official launch of our second phase at the end of last year, we have been very busy planning our activities across Europe and China and delivering new services to support your SME businesses. As most of you know, we are an EU-funded project supporting SMEs to do business in China, and we are implemented by a consortium of 6 partners, including the China-Britain Business Council, the Benelux, Italian, French Chambers of Commerce here in China, Eurochambre based in Brussels, and the European Chamber of Commerce in China. So let me quickly take you through what's new. Although our services will predominantly stay the same, with our first line of advice remaining free of charge, we will be introducing some new features this second phase. As we move forward, we will be providing our services via 3 centres: our Knowledge Centre, Training Centre and Advice Centre. And Ludmila here today is heading up our Advice Centre. New to this second phase is our SME advocacy platform, which we are establishing together with the European Chamber of Commerce here in China. And we will provide access to all European SMEs to take part in an inter-chambers advocacy working group, allowing SMEs to have a voice and to voice opinions on both EU and China-related policy areas. As we move forward, we are looking to strengthen our partners with intermediary organizations across the EU and in China, and we will have a partnership package which makes it clearer on the benefits that our partners can gain from working together with the centre. As you know, we have developed a big knowledge centre which you can access online with a lot of very comprehensive market overviews, technical guidelines and case studies. In this second phase we are going to be focusing on a deeper level, looking at different business modes entering the Chinese market as well as the product level. And from our advice centre we will retain the first line level of advice free of charge, but we will be deepening our service and offering technical solutions that will be charged for. The centre has as one of its mandates to work towards sustainability. So by the end of the second phase, come July 2018, then we will be aiming to be fully self-sustainable. At a glance, you see on this next slide our services that remain accessible via our online website. So to today's webinar, a quick reminder that you can continue to submit any technical issues that you're having, but more importantly, any questions that you may have that you would like to pose to either myself or Ludmila during this webinar. And to do this, you can use your questions panel on your desktop. So a very quick background to Ludmila for those of you who are new to the centre and to our advice centre. Ludmila has over 17 years of experience in legal consulting and helping international investment in China, and she has worked as a legal counsellor for many multinational corporations across China, as well as many years here in China. Across Europe and China, sorry. She has managed the legal and compliance department at a large European financial group and helped their business startup and development in mainland China. At the EUSME Centre on a day-to-day basis, she is of course supporting our SMEs out there and providing all the legal advice that they may need, whether this is in investment law or related to company contracts and also labour law. So at this point, I will pass you over to Lamilla.
Thank you, Anne-Laure, for the introduction. And before we start with the topic about the contracts or how to minimize the risk in concluding contracts here in China, we just like to introduce why we have chosen this topic. When I looked back in our past webinars, I found out that the last webinar on contracts we had 2 years ago, which is quite a long time ago. And since then, I must say that daily or almost weekly basis, we receive several questions which are related to the contract and which might not be asked, and the frauds might not be happen, or issues might not arise if the people who are asking those questions were aware about some very basic problems or advices which are related to the concluding contract generally and here in China specifically. So the basic question is why to have a contract. Many people think that to have a contract in China does not make much sense because they will do their business based on a relationship, based on a guangxi. That's true. I mean, you need to have a good business relationship with your business partners here in China in order your business flourish successfully. But at the same time, to have a good contract will make your situation much easier when things go wrong. Basically, there are two ways of doing business, not only here in China but everywhere. You may hope in a good luck and just go in a pro forma invoice without any signatures, without any paper or exchange of any documents, or go safer way and have something solid in your hands. And about this solid in your hands, we will spend another 40-45 minutes. Many people think that the main purpose of the contract is just the content of the obligation, to know how much shall I pay, or what products shall I deliver, what services shall be delivered. That's of course true, but there are two other not less important aspects of the contract. The first one is a prevention, because if you have a well-drafted contract, it will in some way discourage the other party from breaching it, because if they know that they can be found, if they know that there is a penalty for breaching the contract, that will help to secure your position. And at the end, when unfortunately things go wrong, that well-drafted contract will provide a good protection to you. So what we will speak today about? 3 topics. First, know who really is your business partner. It's very important to know with whom you negotiate, who is on the first page, who is signing the contract. How to conclude a valid contract, because when you decide go the way that you will have something solid, you want to have it useful to you. And the last one is know what to do when unfortunately things go wrong, because this happens very often as well. So chapter 1, does your partner exist? So who is who? Just imagine the situation that you are contacted via email or you met at the exhibition here in China with someone, and you exchange the business cards, you exchange the emails, but in fact you don't know each other very well. So here are some guidelines, some points which you shall be interested in to verify and ask about. Companies in China are registered under their Chinese name written in Chinese characters. So if you receive a business card with an English name or name written in Latin words and letters, it's just for your convenience to do the business with foreign countries more smooth. But it's not official Chinese name of a Chinese company. It's in the characters. And how you will find out this name? It's written on a business license. Business license, as we will see a little bit later, it contains many other very useful information. For example, address. I'll always ask for the complete address in Chinese characters. It's good from two reasons. Again, the transcription might not be to English, might not be correct, but at the same time, when you will be or someone else will be looking in online system of companies, registration system of a companies, this will help to identify, will be one of the points which will help to identify the company well. Legal representative, again, name in a Chinese characters. Any transcript will not help enough when it comes to the identification. Authorized legal representative's name and ID number. It does not happen often that you are dealing directly with the legal representative. So it may be someone who is authorized by this person to act on behalf of the company. Business license number, fixed line phone number. Fixed line phone number, why it is important? Because if you combine fixed line together with the address, you can find out whether it matches or not. If address is in Shanghai and fixed line phone number is going to Xi'an, there is something wrong with it, and you may inquire why this discrepancy happened. So when you will ask your business partner for these 1, 2, 6 items, and you will include it into the contract, then you will like to verify it, and the best is to verify against the business license. Business license is basically certificate of incorporation, and each company registered legally in China possess one business license. In fact, they possess few business licenses. One is this called large business license, and then they possess two same duplicate business licenses. On the screen now you will see one of those small business licenses or duplicate business license. Why we advise to ask for this small business license is because the large one is generally somewhere on the wall in a company and might be accessible to take a picture of, while the small ones, the careful company, they keep it normally in a safe, locked. So it's not available to everybody. As you can see, all the information in the business license are in Chinese language. So you have to have someone who will help you to decode what is it. Each province has the companies, about companies register. Each province has its own company register. So there's a company register for Sichuan, for Liaoning, for Guangdong, for Beijing, for Shanghai. So each system is a little bit different, but in fact, all these informations in the licenses are more or less the same. So if you have that document in your hand, you will know at least registered number, you will know the name of a company in Chinese characters, address, you will know legal representative, and importantly, you will know a scope of a business. Because, for example, if you are interested in dealing directly with the manufacturer, and then you will see on the business license, in the scope of business, that the company is a, as you see on the screen, commercial consultancy or export-import company, they are not really the producers. So you know that you are that you are negotiating with some agent or some intermediary. Of course, every information can be faked or changed, but if you combine and compare all this information together, you will greatly minimize the risk of being cheated. Few words about legal representative. It does not need to be necessarily the director of the company. In most cases it is. But the legal representative is a person who only one, according to the law, is entitled to act on behalf of a company. For example, sign the contracts. So it makes, in every case, it's very useful to know the name of that person. Down the screen on the right side, you will see register. It's an office, administration of industry of commerce, where the company is registered, where it was incorporated. And this information is useful not only when you will or someone you will ask will be doing search on an online database, but it might be useful if you or someone whom you will ask will go to the Quantum Administration for Industry and Commerce. Normally it can be the only lawyer, and will investigate about some other information about the company. So in a Quantum Administration for Industry and Commerce, you will find other documents like articles of association, financial data, and so on. Since March last year, since March 2014, there have been a change in a company law, and this will affect as well something what is called annual inspection, because till the last year there was obligatory annual inspection. Means each company has to every year submit financial statements, licenses, tax registrations for the check, and those documents were they confirmed. And then on a business license, the administration where the company is registered affixed its seal, saying in a simple way, this company is fine, you can do the business with that. It's legally from the tax perspective, it's safe. Since last year, this obligation is not necessary and was replaced by obligation to report. The company has to report itself, has to publish itself information about themselves. So this is enough about content of the business license. But as I mentioned first, and you may rightly ask, to made up, elaborate, fake business license or any other document is not that difficult. So how will I know? Where is the certainty that I have in my hands real business license? Of course, the best way is to go in person and check, but I can understand that not everybody will fly to China to check the business license of the business partner. So what will you do? You will ask for the scan. And then it's at least, if you have this in the hand, it's a piece of information. And then you can check in the online database, or you can ask someone like us here in the center who knows how the business license, the authentic one, shall look like, to verify some information. And moreover, you can call directly to the company itself and verify whether their business license, or whether they know that someone from their company, employee or agent, was in charge or was asked to negotiate on their behalf. So about the first part, the summary and useful tips. How and where did you meet the partner? If you yourself find out the partner, is a more safe way than when someone emailed you, find you over the internet. Always ask for the business license plus some special permits. Compare the information. Compare the fixed line, address, names on business cards, power of attorney. Try to keep a personal contact or send someone whom you trust to verify the information. And our center published some time ago a publication called Knowing Your Partners in China, and this publication contains quite a lot of advices and steps which you can take to verify whether the partner with whom you are going to cooperate is the right one or not. Now, validity of the contract. So when you have finally decided to conclude a contract, to have something, then you would like to have it valid, something what you can use. and because the only valid contract can you help at the end of the day. Here are some points which are considered not only by the Chinese law but generally by the principles of the civil law to when the contract is considered to be valid one. It has to be signed by the parties having capacity to conclude the contract. I will a little bit elaborate on it later. It has to have required form. The content must be legal, permitted by law means, and understandable. Usually it does not make any troubles. And careful about this, some contracts are valid only after the approval of some authorities, means that you will sign the contract, but in order you can, the contract is effective, you have to submit it as letter approved by some authority, like in a case of a technology transfer contracts. So now shortly about the form. Chinese law is it's not conservative at all, as many people can think, and it accepts a lot of forms of how to conclude a contract. It can be written, verbal, or any other form. By written means not only the hard copy, like a paper contract or purchase order, but by written means as well emails, scan, exchange of a fax, and as well electronic systems. All this sounds perfect. Some of them might be some saying perfect, so I will only conclude contract via emails. The problem comes when you have to prove the authenticity of the emails. Just give you example. If you have nothing concluded, you haven't signed anything, job, anything, you have just exchange of the emails, and you would like to use it as a proof at the court, then that's one of the cases. I'm not saying that it will happen if every case, but there was a case. You have to invite notary at your home country to your company, open the server. Notary will verify that the email were sent or received from your account, or that will receive on that specific server. Then the notary report has to be translated to the Chinese, will have to be notarized, legalized, and only then might be submitted Chinese court, and Chinese court may or may not accept it. So having emails, it's perfect, it's fast, it's quick, but problems come when one of the parties will start challenge the validity of the obligation. Same applies to the verbal contract. What might be useful for concluding the contract is that the performance of major obligations might be also considered as a concluding of a contract. So, for example, if one party delivers 60% of the goods already, then it cannot claim that the contract was not concluded, even there is no exchange of the papers between them. Something from this part I have already mentioned. It's not that the contract, when it's signed by someone, will not be valid, but it means that the liability from the contract does not need to be necessary, that the party who is at the beginning of the first page of the contract does not necessarily need to be liable from the contract. So in all cases, as I mentioned at the beginning, it's important to know who is the legal representative. Again, it's Chinese name on the business license. When you will be speaking with someone else, ask for a position of that person and within the company, and verify with someone third. Do not rely on information provided by that contact company, by that contact person only. It's probably very difficult to meet every person you are negotiating with, but suggest at least a video call. It works quite well. You will see the face, you can take pictures, and then if something goes wrong, you have another piece of evidence. When you are dealing with someone else who is not a legal representative, ask for the written authorization signed by that legal representative and affixed by company stamp. On the next slide, I will mention the importance of the company stamp. And it is not very uncommon to ask for a ID copy as well. I remember when we worked with a company before I joined the center, it was quite common that the party which we were negotiating with, which we were concluding a contract, asked for the ID copy, passport copy of our legal representative, in addition to our business license. And same we did, we asked our partners. Company stamps. Company stamps in China equals to signature in Europe. So when the chairman of the board or the general manager or someone who is authorized in Europe signs the contract, here in China, the company stamp might be enough to validate the contract. Problem always comes with knowing how the right stamp shall look like. There are slightly differences between provinces, sometimes even the cities. For example, the Foshan, here on the picture, you will see the round table, round company stamp, which is a very usual one to use. But for example, I know that the Foshan, the Foshan government, they use the oval stamp. Make sure that the Chinese name on a stamp is always the same as it is in the first page and as it is in the business license. Here are some examples. Sometimes we have seen contracts which are signed, on the first page is an identification of a Chinese name, of a Chinese company, but on the last page there is a stamp which definitely belongs to some Hong Kong company. So it makes already some problems and hesitation about the validity of the contract and who might be liable at the end of the day from such contracts. And now we are at the first half of our session today. And we have a question. So before we launch the polls, just quick sample. What you can learn about the following business partner. Just imagine that you have a contract if in front of yourself, and on the first page is identification of the country, Meiyingye Company Limited, with address Fuhua Yilu, Guangzhou, China. And on the last page there is this stamp and a signature of Mr. Wang. The question is it a Chinese company with legal representative called Wang? Or is it a Hong Kong company with authorized person Wang? Or is it a Chinese company with seat in Guangzhou? Or none of the above? So just remember these 4 points, and Laura is going to launch.
Yes, so I'm going to launch the poll now. So I think you've had enough chance to look at that slide. So as I launch the poll, think about which answer you will be choosing. So there was the circular seal with the company name, Meiyingye Company Limited. So which of the following is correct? Is it a Chinese company with legal representative called Wang? Is it a Hong Kong company with an authorized person called Wang? Is the Chinese company with a seat in Guangzhou? Or is it none of the above? So I just give you a couple more moments to put in your answers there. I think most of you have registered your answers. Okay, give you 3 more seconds. 3, 2, 1, and I close the poll now. So let's just share the results with you.
Yeah. Okay, for the option 1, Chinese company with legal representative called Wang, 14%. Option 2, Hong Kong company with authorized person Wang, 37%. the least is Chinese company with seat in Guangzhou 5%, and none of the above is 44%. In fact, I think that the last one, not I think, I'm pretty sure that the last one is true. The reason is that you cannot say anything based on these informations. You cannot say that it is a Chinese company because first, the name is in English. Second, you cannot say that Mr. Wang is authorized person because you haven't seen the business license, neither the power of attorney. And the only thing what you can say is that the company stamp looks like company of a Hong Kong companies. So now you'll see how important it is to ask for the business license and be equipped with some information, what to check, where to check, what to watch. Well, now the third part is when things go wrong, because this is one of the parts when most people are looking at the contract, are interested what is really written in the contract, what is the provisions about, for example, dispute settlement, the sanctions, and so on. This might reply as well to one of the questions which we have received, which sounds a little bit like...
Yes. So, sorry, I interrupt you here, Ludmila. Just because this question is comes from the first couple of chapters that you've covered. Yeah. So, Ricardo is asking why do all these elements need to be checked? It seems that from what we are saying here, we're painting a rather bleak picture of doing business in China. Is that really the case?
No, of course it's not the case. I mean, this is what I have to say, that majority and the vast majority of the companies, Chinese companies, are honest one, and they are willing to develop a business with other companies, with foreign companies. Unfortunately, those who are not that honest are quite visible and very active, and they are creative and innovative, and they are active in searching for the business partners and also called business opportunities, and their intentions might not be often that clear. And our one of our purposes of the center is to help companies come to China, but as well to help them to understand difficulties and avoid unnecessary mistakes.
As part of the inquiries that we receive on a regular basis of the legal content, I mean, a large majority are looking to check or to verify their business contacts, right? Their business documents and partners.
Yeah, that's true. About 20% of our inquiries are either checking a business partner before they will conclude a contract or will do any business. Unfortunately, some of them are coming too late when the fraud or something, I mean, unpleasant happened, and only then we find out, or they find out, what should be checked or not. So take this one as a prevention, not as a discouragement of doing business with Chinese partners. Well, but sometimes it happens that things go wrong. What does it mean? Things go wrong. There might be two types of the situations. First one is like that both parties from the very beginning intended to fulfill the contract, but on the way something changed. Manufacturer was closed. I mean, company went into some difficulties, so the contract cannot be fulfilled. This first case I call a regular contract and regular commercial dispute if comes to this dispute settlement. Another type of a situation is that one party planned the fraud already from the very beginning, and there are cases like this. They are. This means that the contract is not valid from the very beginning because there was a missing good faith of one party to fulfill the contract. However, it does not mean that there is no obligation. But the obligation is not obligation from the contract, but obligation coming from unjustified enrichment, and of course it's connected to the criminal liability. So I start with the fraud. What can go wrong with the fraud? And there are some points which I'm pretty sure, and I have seen some on our list of our participants, law firms and the consulting firms, and that you probably have clients or you have met with the cases like this. So fraud, normally, contact person cannot be contacted anymore. You paid already 30, 50, 70% of a purchase price, and now the contact person disappeared. Contracted party does not exist at all, never did. Name was made up. Business license was stolen or faked. No goods is provided, or something of a minimum value is provided, so the scam is obvious. My cannot say favorite because it was a very sad situation, as always is, was the one company ordered from China a container of several containers of displays like monitors, and what was delivered were teddy bears. So, well, it was probably not the same value. Then another way of fraud is payment to account which does not belong to the company with which contract was concluded. Samples of goods. European companies were asked to provide samples of goods with the promise that there will be large purchase later on. Well, nothing like that happened. Normally with these type of frauds, what is connected is that some kind of administration fees, like notary fees, are asked, and there is no legal basis for this, and many others. So what to do when things like this happen? I will not paint the picture pink because there is really not that many what you can do when you were, victim of a scam. But still, there is something what is possible to do. First, you have a look on information which you have. If the other party was creative and made you subject of a fraud, be creative too. Try to collect as much as information as you can about the contact person. Have pictures. Therefore, I mentioned at the beginning that it makes sense to have a video call with the person. If someone does not want to show the face, it's a sign of something. Collect phone numbers, addresses. We have a client here who was quite smart, and he said, I cannot contact a company anymore. They do not communicate with me, but when I use another email address, they will contact. They keep answering this. So this is what at least you can do. Of course, depending how much time and effort you want to invest into it. May English and Chinese summary of your case, including the loss calculation, all evidence you can submit. And if the loss is substantial, consider hiring external assistance. It does not need to be necessarily a law firm at this point of day. It can be agent, someone who will help you to submit these documents to the appropriate authorities. And then report to the competent authorities. You have basically two options: administration of industry and commerce, complaining about the company itself, if it exists or not, but you can send this the report, and Public Security Bureau for the criminal offense. If evidence is sufficient and the damage was substantial, you may think about hiring a lawyer and file a lawsuit at a local court.
So here I just interrupt again. Here at the EUSME Centre, we do not provide legal services. However, we can help to check some legal documents such as business licenses, as Ludmila has mentioned before. if you are interested in looking for further support, so we have on our website a service providers database, and here you can search for different service providers, including lawyers, law firms, and you can find some contact details there to follow up on any particular issue.
Now we come to a little bit less set case, which I call a regular contract. But again, what can go wrong, and what are the signs that which are normally connected with the breach of the regular contract? Delay in delivery, substantial delay, delay in payment, partial payment, quality of products does not corresponds to what was agreed, increase of price, the other party is asking for the increase of price, or impossibility to fulfill the contract at all. This can be, if you encounter situations like this, it does not necessarily would mean that it's a fraud. It can be regular contract, and you still can have a way out of it. So what to do when you encounter problems like this? First, identification of the business partner. Normally, it is not the problem in this case to identify and keep in contact with the business partner. What is challenging is to recover the loss. Chinese companies, they don't like going for the disputes. It damages reputation, it's loss of the face, it costs money. They don't want to go to disputes. So if they want to keep you as a customer, or if they want to somehow get away in a way with you, they will negotiate. Try to ask them for some discount. Maybe you would be satisfied with another product. But there is one thing, that this probably will not go without your personal presence here in China. It cannot be done via email or on the phone. However, when the friendly negotiation fails, again, calculate your loss. And then you have to do another calculation, which is connected with the arbitration and court fee. Lawyers, legal fee will be covered by you even if you win. If it is, for example, for the litigation, you have to add costs for the notarization and translations, traveling, and so on. So if all this is still lower, substantially lower than your loss, it might make sense to start a dispute. However, before you start a dispute, what can be the last chance is to ask a law firm, a local law firm, to send a legal letter. It's kind of a, say, warning and summary what will happen, what you have in hand, or you don't need to tell everything what you have in hand, but it will be kind of a summary what will happen if they are not going to fulfill their obligations. One important point before you start any dispute is to know status, financial status on and assets of the party which you are going to sue. Because at the end of the day, you does not want to win only, you want to recover the damages. And this will not happen if a company does not have any assets, which might happen, for example, in case of Hong Kong companies, then there is no required higher capital. There might be companies with low capital, and then you will not be satisfied. So let's say that you have decided that you will go for the dispute, and you are interested to which court or to which body, which authority you shall send your complaint. Then when the contracts become handy, you have a look at the contract, and if you have any contract, and there will be written something, or there will be written anything, there will be there. So if nothing said about the dispute settlement, then the normal rule is that dispute will be submitted to the court of a defendant residence or to the court where the contract should be performed. However, to avoid uncertainties, it's always helpful to include dispute settlement directly into the contract before you sign one. Now, shortly about the litigation, and it will help you to decide what type of dispute settlement you want to have in your contract. Litigation in China, but generally, is less flexible, and it may take more time, especially when there are two instances where appeal is possible, and then you have enforcement. However, if your business partner is in China, opt for litigation in China, go to court in China. There are a few reasons for it, and one of them is that most foreign court awards are not enforceable in China. So, for example, if you have in your contract that in case of any dispute settlement, you will go to municipal court in Ostrava, Czech Republic, then you may win there. But if you go with this judgment, with this award to the Chinese court, they will look at you. Well, they will not look at you. It's useless. Therefore, the option is litigation in China. Another reason why it's to have, if you decided to go for court, to have a place of litigation or dispute settlement in China is then very often defendant is a Chinese person or a company, and more likely they will have some assets here. So when it's come to the enforcement, it might be easy to enforce and cover the losses. However, what is recommended option is arbitration. It's more flexible. It does not need to be necessarily more expensive. And arbitration awards are enforceable in China. In addition to that, arbitrators are used to decide commercial cases with foreign element. So you will have greater chance to submit your evidence, and they will be more flexible when making decisions, taking into account more information submitted. If you are a company registered outside of China, you can choose international arbitration body like in Hong Kong or Singapore, and but as well, China has a few arbitration bodies like in Beijing or Shanghai, and there are as well good options. But in order you can opt for the arbitration, you have to include it arbitration clause directly into the contract, either at the beginning or later on when the dispute settlement, when the dispute already has arisen. And this arbitration clause has to include name of the arbitration body that matters for the arbitration, language, place, and you can ask as well for the setup of the arbitration tribunal. Last thing about the governing law. First, what is governing law? This is basically a set of the rules and the principles which will apply when it comes to the dispute settlement, and based on which judge or arbitrators will decide your case. Again, some people, they think that if go, let's say, for the Italian, French, or any other law, that will be useful for them because they are familiar with it, they know it. Well, it does not need to be always the case. Chinese law is in many aspects quite a developed one and provides good protection. However, you will not have a choice of the law if both parties are registered in China, which means if you have a WUFI or joint venture in China and your business partner is in China as well, you cannot choose any other law than a Chinese law. choice of law is available only to companies or in a contracts which are so-called foreign-related contracts, which basically means that some of the countries, some of the companies, one party is registered outside of China.
Okay, so I hope that this slide has answered Roger's question here. So Roger has been asking contracts, so should it be then that contracts should only have China as a legal jurisdiction?
No. It does not need to be. The Chinese jurisdiction, let's say that this way, if we are saying about the Chinese law, you have to have your contract submitted and the dispute solved according to the Chinese law when your company and the other party are registered in China. In this case, you cannot opt for the national law. In this case, you will as well go either to the Chinese court or to the arbitration here in China. However, you have a choice of law when your company is registered abroad and your Chinese partner here is China. But here in this situation, it might be more helpful to you to choose the Chinese law. For example, because if you go to the court and you will say in your contract that your contract shall be decided based on the French law, then Chinese court will have to decide based on the French law. But can you imagine, like if you are France, that French judges will know a Chinese law in the opposite way? Very probably not. And as I said, the Chinese law is quite well developed. The only problem is then when it comes to the implementation. About the language, because before we started this webinar, we had one question from one of our clients relating to the language, and in what language the contract shall be concluded, whether in Chinese or English. Well, ideally it is bilingual, but not translated from Chinese to English and English to Chinese and Chinese to English again, because then both versions will not be consistent at all. The best option is that you have one person who will draft, ideally lawyer, who will draft it in Chinese and English at the same time. And then changes, if any changes are done simultaneously in both versions. What will happen when you say in your contract, and things like this happen when both versions are equally binding? Then if you go to the Chinese court, they will look at the Chinese version. If you say that the English version prevails, Chinese court will have to engage official translator. Then this was end of our three main chapters, three main topics, but I have included one more, and these are the tips for other provisions. There are a few other very useful clauses in the contract which normally nobody pays attention to, but which may prove to be very useful when it comes to a dispute or some discrepancy. Often it happens here in China that companies, before they enter into the final contract, they conclude something like memorandum of understanding or framework agreement, and then they decide that they will conclude the final contract. But they do not say it in the letter contract directly. So sometimes it may happen that both contracts are valid and at the same time, and it may happen that some of the provisions of contract 1 and contract 2 are one against each other. So it makes sense to solve the validity of the previous contracts, memorandum of understandings and correspondence in the letter contract, in the latest contract, and say what provisions are valid, what are not, or the best way is to say that this new contract is concluded as the will of both parties, and everything what was concluded before is not valid anymore. Other clauses and the provisions, contract termination, extension, and then renewal, confidentiality. Even before concluding the contract, you may have some simple letter, a simple one page saying that both parties will be obliged with mutual confidentiality while negotiating about the contract. Language I have mentioned, and annexes to the contract. Very useful part, business licenses, scans of ID cards, technical specifications made it part of the contract. Last slide, takeaway. Conclude a valid contract is neither difficult nor time consuming. Good contract can be drafted, I cannot say within one day, but it can be drafted on 2 pages. And it will provide quite sufficient protection. Absolutely crucial is to verify your business partner, to know with whom you are dealing with. Business license, who is legal representative, signing, and so on. Level of your protection at the end of the day will depend on what evidence you can submit. Be conservative, go for paper, go for signatures and the chops. And last, and in this point, I will give floor to Anne-Laure to make a summary.
Okay, so we come up to the last 5 minutes of our today's session, and we're going to be moving into answering a couple of questions that have been asked. If we don't get round to answering all of the questions that you have posed to us, because there are many people listening into today's webinar, then I will invite you to visit our website, www.eusmecenter.org.cn, and from the home page you register, and there is an Ask the Expert button where you can submit your inquiries there. Nevertheless, we're talking today about the validity of contracts and having correct and valid contracts. We mentioned it a little bit before. The EUSME Center can help you to verify these business licenses against the online administration of commerce databases and other databases here. And if you have a draft of your contract that you would like us to review before signing on the dotted line, then also please do not hesitate. So, Lamilla, we have a couple of questions here from Mark. So Mark is listening in and asking, in the case of a dispute between Chinese and Western company or foreign company, are the Chinese judges impartial or partial to Chinese companies in this sense? So this is the first question.
Mm-hmm. As for the first question, well, I cannot say it's not completely true, neither I can confirm it. There are cases where the judges were partial to the Chinese companies, but I must say that Chinese government, they pay quite a lot of attention to train the judges to deal with the foreign companies, foreign element. So I have seen recently some news that there were new judges, I think it was in Shanghai and Guangzhou, probably in Beijing as well. They were appointed new ones, and they had a special training related to deciding disputes with the foreign element.
Okay, thank you. And Xiaojing is asking, is the legal representative the only person that can sign a contract?
Based on the law, the legal representative is the person who is authorized to sign the contract. However, there can be other people, of course, in the company who can sign the contract, but to be on a safe side, ask for the authorization letter signed by legal representative and chopped by company stamp.
Okay, I'm going to take, for the interest of time, I'm going to take 2 more questions. And a question here, does it make sense to use the non-competition clause in the contract?
If you mean a non-competition clause in relation to the like exclusivity or well, I will cover it like exclusivity. I think of course it makes, but just it has to have some conditions under which the non-competition provision is asked.
Okay, and Gianfranco is asking, is it preferable or compulsory to get the contract written in both languages?
No, it's not compulsory. You can have contract written in let's say in Polish language if both parties agree on that. Difficult will be then with probably the Chinese party will not understand it, but you don't need to have bilingual. It's not mandatory to have bilingual contract.
So we are, for the interest of time, we are coming to the end of today's session. If you have any other questions, please visit the website and pose them through the Ask the Expert channel. These inquiries will be sent directly to our advice centre, and so we will be able to answer them. Just a quick summary then of our advice centre, led by Ludmila, who spoke to you today. We do continue to offer our first line information and advice. You see some typical questions on the screen here. We do offer now other technical solutions, and for those you can see them on the following slides. Business model viability we will be dealing with, as well as checking contracts and other legal documents, which we explained today. We'll look at market access, standards and labelling. On the HR element, how to employ people, including advice on visa applications. And we will be able to conduct some partner verifications, distributor agent searches, and also do tax calculations. So for any of this information, you can go to our website and ask the expert. I want to thank you all for listening in today, and you will be, by registering on our website, you will get access to our monthly newsletter and mailings, which will update you on our activities to come. So I thank you for listening, and until our next webinar, we'll see you then. Thank you. Bye-bye.
Goodbye.